Just one moment. All right. Everyone, please make sure your phones are on silent or off. Court is calling 2024 CR 008420. State versus Johnny De La Rosa. Can I have parties announced for the record?
Megan Galloway and Lauren Espinosa for the state.
Robert Malford, defendant, judge.
And are you Mr. De La Rosa?
No.
All right. My understanding is all the jurors are present. Are both parties ready to proceed?
Judge, co-counsel went to get a bottle of water and be right back. I'll be ready.
All right. And each party will have 20 minutes. So, Ms. Ferguson, each side is going to get 20 minutes. Alejandro Juarez Gonzalez. Juliana Guzman. Jonathan Carter. Clarence Lacey. Carlos Gonzalez. Michael Eugene Hernandez. Miguel Alatorre. Darren Villarreal. Alonzo Whittington. Serenity Avalos. Christopher Mendez. And then Savannah Gutierrez is in back. Right. We're ready.
All right, Ms. Jury.
Yes, ma'am. All right, everyone, please be seated. All right, so ladies and gentlemen, as you can see, the courtroom is filled. This is my morning docket, but we're going to take this matter up first. I'm going to read to you what's called the charge of the court. You do not have to memorize it. You will be given the original when you begin your deliberations. Members of the jury, the defendant, Johnny De La Rosa, stands charged by indictment with the offense of aggravated assault with a deadly weapon alleged to have been committed on or about April 9th, 2024 in Bexar County, Texas. To this charge, the defendant has pleaded not guilty. Our law provides that a person commits an assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. A person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Self-defense. You are instructed that it is a defense to this prosecution if the conduct of the defendant was justified by law. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. You are instructed that the use of force is not justified, 1, in response to verbal provocation alone, or 2, if the actor provoked the other's use or attempted use of unlawful force, unless A, the actor abandons the encounter or clearly communicates to the other his intent to do so, reasonably believing he cannot save the other, nevertheless continues or attempts to use unlawful force against the actor. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person has a right to defend himself from apparent danger to the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at the time. A person, 1, who has the right to be present at the location where the deadly force is used, and 2, who has not provoked the person against whom the deadly force is used, and 3, who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force. If all 3 of these factors are met, then in determining whether such actor reasonably believed that the use of deadly force was necessary, a finder of fact may not consider whether the actor failed to retreat. The defendant is not required to prove self-defense. The state must prove beyond a reasonable doubt that the defendant's conduct was not justified by self-defense. Therefore, keeping these instructions in mind, if you find from the evidence beyond a reasonable doubt that Johnny De La Rosa committed the offense of aggravated assault with a deadly weapon as charged in the indictment and as instructed in paragraph 5, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, one, Johnny De La Rosa reasonably believed, as viewed from his standpoint, that Nadia Newton was using or attempting to use unlawful deadly force against Johnny De La Rosa, and two, Johnny De La Rosa reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Nadia Newton's use or attempted use of unlawful deadly force. And three, Johnny De La Rosa's use of deadly force was not in response to verbal provocation alone. Four, and you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, A, Johnny De La Rosa did not provoke the attack on him by Nadia Newton. Specifically, Johnny De La Rosa did not do some act, and Johnny De La Rosa did not use some words that were reasonably calculated to provoke the attack on him by Nadia Newton. Or B, if Johnny De La Rosa did such act was not done by Johnny De La Rosa, and such words were not used by Johnny De La Rosa for the purpose and with the intent that Johnny De La Rosa would have a pretext for using deadly force upon Nadia Newton. Or C, even if they were, such act and words did not in fact provoke the attack on Johnny De La Rosa by Nadia Newton. Or D, if Johnny De La Rosa did initially provoke the attack on him by Nadia Newton, he thereafter abandoned the encounter or clearly communicated to Nadia Newton his intent to abandon the encounter, reasonably believing he could not safely abandon the encounter, and Nadia Newton nevertheless continued or attempted to use unlawful deadly force against Johnny De La Rosa, then you will find in favor of Johnny De La Rosa on his claim of self-defense, and you will therefore find that the state has failed to prove beyond a reasonable doubt that Johnny De La Rosa was not justified under the law of self-defense, and you will therefore find the defendant, Johnny De La Rosa, not guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment. However, if you find from the evidence beyond a reasonable doubt that Johnny De La Rosa committed the offense of aggravated assault with a deadly weapon as charged in the indictment as instructed in paragraph 5, and you further find from the evidence beyond a reasonable doubt that one, Johnny De La Rosa did not reasonably believe, as viewed from his standpoint, that Nadia Newton was using or attempting to use unlawful deadly force against Johnny De La Rosa, or two, Johnny De La Rosa did not reasonably believe, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Nadia Newton's use or attempted use of unlawful deadly force, or three, Johnny De La Rosa's use of deadly force was in response to verbal provocation alone, or four, you further find from the evidence beyond a reasonable doubt that Johnny De La Rosa did provoke the attack on him by Nadia Newton. Specifically, Johnny De La Rosa did do some act or did use some words that were reasonably calculated to provoke the attack on him by Nadia Newton, and B, such act done by Johnny De La Rosa or such words used by Johnny De La Rosa were reasonably calculated to provoke the attack on him by Nadia Newton, and C, the act was done or the words were used for the purpose and with the intent that Johnny De La Rosa would have a pretext for using deadly force to inflict harm upon Nadia Newton, and D, such act or words did in fact provoke the attack on Johnny De La Rosa by Nadia Newton, and E, if Johnny De La Rosa did initially provoke the attack on him by Nadia Newton, he did not thereafter abandon the encounter or clearly communicate to Nadia Newton his intent to abandon the encounter, reasonably believing he could not safely abandon the encounter. And even if Johnny De La Rosa did do either of these things, Nadia Newton did not continue or attempt to use unlawful deadly force against Johnny De La Rosa, then you will find against Johnny De La Rosa on his claim of self-defense, and thus you will find that the state has proven beyond a reasonable doubt that Johnny De La Rosa's conduct was not justified under the law of self-defense. Therefore, if you unanimously find that the state has proven beyond a reasonable doubt all of the elements of the offense of aggravated assault with a deadly weapon as charged in the indictment, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant was not justified under the law of self-defense as instructed herein, then you will find the defendant, Johnny De La Rosa, guilty of the offense of aggravated assault with a deadly weapon as charged in the instrument. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about April 9, 2024, in Bexar County, Texas, the defendant, Johnny De La Rosa, did use or exhibit a deadly weapon, namely a firearm, or recklessly caused bodily injury to Nadia Newton by shooting Nadia Newton with said deadly weapon, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Johnny De La Rosa, did not act in self-defense as instructed in paragraph 4, then you will find the defendant, Johnny De La Rosa, guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers or tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times statements in reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is herein given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this case, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 Judicial District Court, Bexar County, Texas. Suitable forms are attached. Ladies and gentlemen, each side will have approximately 20 minutes to give you their closing arguments. State, are you prepared to proceed?
Yes, Judge.
All right.
Ladies and gentlemen, when we started this trial, Ms. Galloway stood up here and told you it was not a who done it. We had the surveillance video and evidence to show exactly what happened. Here, we learned through the evidence that on or about April 9th, 2024, an ag assault with a deadly weapon was committed by Mr. De La Rosa against Miss Nadia Newton. He stopped her when she was walking on April 9th, 2024, as she was walking down the sidewalk along Vance Jackson Road. He almost cut her off with his vehicle. They engaged in conversation and argument. Both pulled out their telephones and recorded one another. Throughout their interaction, Miss Newton's phone got broken and that video was unable to be recovered. However, what was recovered was Mr. De La Rosa's video. In the video and in the surveillance, it shows Miss Newton backing away from Mr. De La Rosa and Mr. De La Rosa proceeding toward her, saying to the effect of, you're not getting away. You're not going to leave. Miss Newton presented a weapon, her pocket knife. She did this because she feared for her life against what Mr. De La Rosa could do. There was a witness, Mr. Travis. Travis worked at the car wash. He came out. He also observed what happened. You also heard from several officers that responded to the various scenes after the altercation, where Miss Newton did end up stabbing Mr. De La Rosa once. But in response to that, unlawfully, Mr. De La Rosa shot Miss Newton in the leg. These officers responded to the respective scenes of Miss Newton and Mr. De La Rosa and took statements from both. You also heard from several detectives in this case. Ladies and gentlemen of the jury, you have heard all the evidence that shows that this was not an unlawful use of deadly force by Miss Newton, but in fact, it was an aggravated assault of a deadly weapon against Miss Newton by Mr. De La Rosa. And in a minute here, Miss Galloway will get up and tell you more detail and expand on how the elements of this offense are met by the evidence presented to you. Judge, I'll present the rest of my time.
Proceed.
Yes.
Ladies and gentlemen, I want to remind you what we talked about during voir dire and how the people who were selected for the jury agreed that they were going to follow the law, right? So if you recall, at the beginning of this trial, the state read the charging instrument against Mr. De La Rosa and essentially did use or exhibit a deadly weapon, namely a firearm. And so the reason I bring that up is because you heard the last detective talk about this whole totality of the circumstances and things about the vehicle, right? So there's no totality of the circumstance. The state is the one that chose the charge. They're the ones that indicted the case. So they're the ones that have to meet the burden of whether or not the charging instrument is actually the burden is met. So let's talk about what we have. So you have the video. You see Mr. De La Rosa pull over in front of the complainant. There's a brief argument. The complainant walks off and then comes back. Okay? Then after that, you see the two people arguing with each other. You see the videotape from Mr. De La Rosa where they're both filming each other, both talking to each other. And then the entire time that's going on, Nadia has a knife out. Now, Johnny is not exhibiting a firearm. There's no mention of a firearm. Nobody talks about a firearm until much later. So Nadia knocks Johnny's phone out of his hand twice and then runs towards his car. Johnny follows her. One of the things the detective talked about was cutting off the line of escape. Well, there's no line of escape to cut off. She ran, stopped in front of the vehicle. She had left earlier and then came back. So it's hard to argue that there was a line of escape that had been cut off. And then at some point in time, Nadia stabs Mr. De La Rosa either once or twice in the lung. And then Mr. De La Rosa is knocked to the ground by Travis. It's only then after he's been stabbed and knocked to the ground that he pulls the firearm out. Now, the detective is making an argument that his use of force at that time wasn't justified, but that's up to you to decide, right? In a situation where you've already been stabbed, you've been knocked to the ground by a larger individual, and you have two people standing there, including one with a knife, then it's kind of a decision. You have to put yourself in his shoes to decide whether or not that's reasonable. But just remember, there's no use or attempted use of any sort of force by Johnny De La Rosa. They're sitting there talking, okay? There's no deadly force used until Nadia stabs him. So I wonder, had Johnny not fired a shot, whether or not Nadia would have been charged actually charged as a defendant, because she's the one that came back to the scene, right? Knocks the phone out of his hand, runs to his vehicle. I guess the theory is, could she have been trying to steal the car? The engine's running, right? The lights are on. But then at some point in time, she makes the decision to stab him. So you're going to go through the jury charge, and it's kind of your roadmap, right? So the important thing the judge talked about is the state must prove beyond a reasonable doubt that Mr. De La Rosa's use of deadly force was not justified, that self-defense was not justified. Okay? So look at this situation. You have two individuals sitting there arguing with each other. You know, they're filming each other, they're talking crap to each other. Obviously, they know each other. But there's no force used, right? By anybody until Nadia stabs him. Johnny, I mean, she has a knife out. Johnny doesn't have a gun out. You see the video from the car wash, okay? There's no exhibition of a weapon or anything else until after Johnny's been stabbed and knocked to the ground by this other individual. Okay, so one of the things you're gonna go through this, you're gonna pick a foreman and you're gonna read through the jury charge, and you'll have to look at these different sections and apply them to the evidence you've heard. And the important part, when you get to the part about provocation, and in a minute, Ms. Galloway is gonna get up here and argue that Johnny De La Rosa provoked the situation by pulling over in front of her in the parking lot, even though she subsequently walked away and then came back. Okay, but as the judge talked to you about, you have to find one that he provoked the attack, right? And then the most important part, you're going to go through A, B, and C, and it says, and the act was done or the words were used for the purpose and with the intent that Johnny De La Rosa would have a pretext for using deadly force to inflict harm. So you have to get to the point where you have to say, he did all this just so he could provoke Nadia so he could shoot her. That's what the law says. Okay? And if you don't find that, then he's not guilty. And if you look at the totality of the circumstances, as the detective talked about, and you look at the video, the only person exhibiting a weapon at all is Nadia for almost the entire time. The person who used deadly force is Nadia, right? And then Johnny's knocked to the ground, and only then, after he's been stabbed and knocked to the ground, does he pull his weapon out. So you have to show that this pulling over or this argument was all a pretext so he could use deadly force against her. Well, if that's the case, why didn't he have his gun out initially? She has her knife out. He could have pulled his gun out and say, yeah, she was threatening me and I shot her. He wasn't doing that. They were arguing. Clearly, they knew each other, and it was an argument between two people. I mean, it was kind of a childish, silly argument. But if you follow the law as it's given to you in this jury charge, you have to show he did these acts with the intent to have a pretext for using deadly force. He did all this so he could shoot her. Well, that's clearly not the case. You saw the evidence, right? Even Detective Martinez said, this doesn't justify somebody being stabbed. You know, the second detective talked about the line of escape and, you know, pushing somebody out in the roadway. Well, you'll have to make a decision. You can freeze frame that and look at it as many times as you want, because I don't think his analysis is actually accurate. But at some point in time, Johnny De La Rosa is stabbed, and the only important thing you have to decide is, was this entire scenario essentially a setup for him to do this? I mean, you look at the situation, clearly it's spontaneous. It's an argument between two people, but there's no use or exhibition of deadly force by Johnny De La Rosa until after he's stabbed. So if you follow the law, you can't find him guilty because it doesn't meet the standards for provocation. You can commit an act and you can say words, but unless the act was done, the words were used with the intent to have a pretext for using deadly force, then you can't find him guilty. It doesn't meet the basis for it. Okay, you heard from the witnesses. Nadia admitted that there was no gun seen at all until after she'd stabbed him. Right at that point in time, it's an argument between two people who know each other. Okay, and I mean, it's pretty clear cut. If you follow the roadmap of this jury charge and you follow the law, right? So we'll agree, yeah, there was a shooting. There was also a stabbing. Positions could have been switched, I mean, depending on what the detectives decide. Obviously, at some point in time, Nadia had been charged, okay? But if you follow this roadmap and you follow the law we have here, you have to look at this and make a determination. Did he do this, pull over, and have an argument just to have the pretext for using deadly force? Well, if he wanted to have that, why wouldn't he have done it once she pulled the knife out? He was still arguing. He was having a conversation with her. A childish one, I'd agree, but it's still a conversation. Nobody has any idea Johnny has a gun until after he's been stabbed and knocked to the ground. So what you have to do is go back there. Once you pick a four person, and you're going to walk through the law, and you're going to look at the evidence and see how it comports with the jury charge, and what you're supposed to look at. And so if you follow the law as you see in this jury charge, right, then clearly the state cannot meet their burden to show beyond a reasonable doubt that Mr. De La Rosa did not act in self-defense, because there's nothing here that shows that he did any of these with the pretext of trying to use deadly force. He pulled over, they were having an argument, but he never exhibited or used deadly force at all until after he was stabbed. Okay, so Megan's going to get up here in a minute and talk to you about what they think about things. All you need to do is go back there, look at the jury charge, read through it, and then apply the law to the evidence you heard. And I think clearly you're going to find Mr. De La Rosa not guilty.
Judge, if I may have a. Do it. Do it. These are the words that were uttered by that defendant sitting over there seconds before Nadia stabbed him while she was in the middle of Vance Jackson. Ladies and gentlemen, this statement made by the defendant at the time of the offense proves that he adequately provoked Nadia's use of force. And those words, in conjunction with his behavior at the time of the offense, prove that he was acting with the intent to have a pretext to use deadly force against Nadia. Ladies and gentlemen, at the commencement of this trial, I told you all, it's not going to be a whodunit, okay? We've brought you video evidence, and I'm going to talk to you about the law that supports that we have met our burden and that we have disproved the defendant's claim of self-defense. By them claiming self-defense, this is a stipulation, okay? He is admitting that it was his intent and desire on the date of the offense date to shoot Nadia Newton and cause her bodily injury. Therefore, when you retire back to the jury room, all of the elements that you see up here on or about the date in Bexar County, the defendant intentionally caused bodily injury and used a deadly weapon, those are all checked off, and we have met our burden there. But I want to talk to you about the assertion of self-defense. So what does the law say about self-defense? And I'm going to add that just because you receive an instruction about self-defense, that does not mean that the court is commenting on the evidence in any way, okay? It's something that they are entitled to, and it's something that you are going to parse through when you get back to the jury room. But let's okay, a person is justified only when and to the degree the actor reasonably believes that force is immediately necessary to protect themselves against the use of another's unlawful force. Okay, so there's really 4 prongs there that we're going to talk about. So when you're back there in the jury room, the reasonable belief, what is that? Okay, and it's in the jury charge. It is a belief held by an ordinary and prudent person in the shoes of the defendant. Okay, so this is not a person that would hunt somebody down like a bloodhound on Vance Jackson when they're walking and minding their business. Okay, this is an ordinary and reasonable and prudent person. So let's talk about the use of force. All right, Nadia was not using unlawful deadly force against the defendant, and we'll talk about that in a little bit. The defendant did provoke Nadia's use of force against him. The defendant did not abandon his encounter of Nadia, and his intervention was not immediately necessary to protect himself. So let's talk about the evidence that you all saw during the duration of this trial, right? Nadia Newton was not using unlawful deadly force, okay? There's all this argument that she had the blade out the entire time. I urge you to go look at State's Exhibits numbers 4 and 5, okay? And in State's Exhibit number 5, which is the cell phone video, you will see that at the beginning of the interaction, which I would hardly call an argument, okay, it's her telling the defendant continuously, get away from me, leave me alone. And he is relentless in his pursuit of her, okay? So let's look at State's Exhibit number 5 when you go back there. When you look at it, the blade is not even produced, okay? She just is holding it with the blade folded in, and she's telling him, get back. The blade is concealed. And at this point, she's creating an apprehension that she will use deadly force if needed, okay? Then what happens next in State's Exhibit number 5? Nadia turns her back, and the defendant follows her. And she's walking like this, telling her, get away from me, get away from me. And him, relentless, advancing towards her. The blade is still concealed, but what we are seeing in State's Exhibit number 5 is a continual escalation in the defendant's behavior. And it's not until 55 seconds that the blade is actually produced, okay? She had a right to defend herself. You heard her testimony. She was in fear and she did not know what he was going to do. She told the defendant to leave many times, and his behavior of advancing towards her and chasing her created a reasonable apprehension of danger for her. So in State's Exhibit number 5, she will close the blade again, and at 2 minutes and 7 seconds, she reproduces that blade. And that is as the defendant is advancing toward her, basically corralling her into the middle of Vance Jackson. And I've clipped a still shot from State's Exhibit number 5, and what you see in there is from 2 minutes and 7 seconds, okay? That blade is not produced, and that light that you see in the top left corner is a motor vehicle. The defendant did provoke Nadia's use of force. And this is where we're going to talk about the totality of circumstances. If we want to talk about him having the intent and doing acts and words using or to create the purpose to use deadly force, these are the acts, okay? He aggressively cuts her off while she's minding her business, walking on the sidewalk. He's not heeding to the warnings that she's providing to him. He is advancing toward her and chasing after her, and she is walking backwards, and you're going to continually see that when you retire to the jury room and look at the evidence. You're going to see a lot of this, okay, because that's what she was doing. And he never abandoned the encounter, okay? He's continuously advancing toward her, no matter where she goes, advancing toward her. And it was not immediately necessary. Now, I want you to go back and look at State's Exhibit number 5. And what you will see is that the defendant closes in on Nadia in the street, okay? That is when she finally stabbed the defendant, all right? And what he does is he immediately produces his firearm and he points it at her and he says, you stabbed me. That is when Travis went and pushed him over after he produced the gun, and that is clearly exhibited on State's Exhibit number 5. The defendant gets pushed to the ground, and then he gets up and shoots Nadia. And self-defense is very fact specific. You need to look at these facts and circumstances that I am explaining to you, because immediately necessary is not met. At the time that the defendant produced his firearm, Nadia was backing away from him, and she was no longer exhibiting any type of force to him. Regarding the presumption of reasonableness, okay, the defendant is not entitled to that because he provoked the entire encounter and did not abandon. The evidence supports a finding against the defendant's assertion of self-defense, and we have proved that to you beyond a reasonable doubt. Now let's talk about the testimony that you heard over the past couple of days. You heard from Officer Varas, okay? He responded to that Perry Brook location. He observed Nadia with a gunshot wound to her left leg and observed her in a great amount of pain. And Nadia is forthcoming in her statement to Officer Varas, okay? She immediately says, yes, I did stab him after he aggressively cut me off and I gave him many warnings and he continued to pursue me. Nadia tells a full story, okay? And she also tells Officer Barras that she was in fear because she knows the defendant to carry either a knife or a firearm. Then you heard from Officer Dimmitt. He's dispatched to the Briargate location, and you all saw the condition in which the defendant was in when Officer Dimmitt arrived there. But the defendant leaves out major parts. Okay, all he says at that point is, I did shoot her. I defended myself only after she stabbed me. That's not the full truth, ladies and gentlemen. Then you heard from Detective Pelkey. Okay, she photographed the crime scene, that car wash there on Vance Jackson Road. And she did not locate any weapons.
Gentlemen, we approach.
On scene. And it's no wonder why, because if you go and look at State's Exhibit number 4 at 7 minutes and 58 seconds, okay, you see the defendant going into the street, hopping down and picking his shell casing up, and then getting back into his car before he leaves the scene. Ladies and gentlemen, that is not the behavior of somebody who is justified. Then you hear from Nadia Newton, okay? And she states she was in fear, she had no way out, and her statement is corroborated by State's Exhibits number 4 and 5. And you heard from Travis Phillips. He stated that the defendant was so aggressive that he felt that he needed to intervene and stay there and ensure Nadia's safety. And then he testified that he pushed the defendant to the ground only after the firearm was produced, okay? And all of that, all of his statements are corroborated by State's Exhibits number 4 and 5. Nadia and Travis are consistent with each other, and they have been since the offense state, and they are corroborated by the video evidence. Now let's talk about Detective Martinez. He goes to University Hospital and takes a statement from the defendant. And ladies and gentlemen, at this point, without the video evidence, it is no wonder why they erroneously arrested Nadia. Okay, because here the defendant goes, leaving out major parts of his statement. Oh, I just got out to talk to her. Oh, I didn't push her. Oh, she ran out to Vance Jackson. She darted into the middle of Vance Jackson. I was just trying to help her. That is not supported by the evidence in this case. He stated that he didn't produce the firearm until after Travis pushed him, which is another blatant lie. And all of those statements are dispelled by State's Exhibits number 4 and 5. Then you heard from Detective Bowder. He is the one that received the case. He obtained the video evidence. He watched it. And in his analysis, he testified. It was a totality of the circumstances. All of the things that we talked about are what led him to recommending that the charges against Nadia be dropped and that the defendant be charged and have to answer to 3 of his peers for his behavior. Okay. Ladies and gentlemen, you are the exclusive judges of the facts that were proven and the credibility of the witnesses. And so I ask you, what does Nadia have to gain by coming up here and testifying? Absolutely nothing. At this time, your sole duty is to determine whether the defendant is guilty or not guilty. And we have proven to you beyond a reasonable doubt that he committed these acts and that he was not justified by law. Now, what our not defense is that Nadia cursed at him, that Nadia slapped his foot, or even that Travis pushed him. Okay? In your jury charge, you are instructed that you are not to allow sympathy, bias, or prejudice to play any part in your deliberations. You all took an oath to render a true verdict according to the law and the evidence. Ladies and gentlemen, up until this point, Detective Ballard is the only person that actually heard Nadia. And now I am asking you to hear her and find the defendant guilty as charged. Thank you.
All right, ladies and gentlemen, you've heard all the evidence that you will hear. Deputy Laura will take you back to the jury room where you'll pick your presiding juror and then begin your deliberations. And State Defense, if you'll go over the
Good job.
evidence. And Rick,
Yes.
you can review that. And I think if they were negotiating with Ashley.
You're gonna be.
Okay, all right, thank you.
Oh.
All right, Alejandro Gonzalez. Juliana Guzman. Jonathan Carter. All right. Michael Hernandez. Miguel Alatorre. Darren Daniel Villarreal. Alonzo Whittington, I think he was taken into custody. Serenity Avalos. Mary, are you all ready on your issue?
I think probation has given me the report. I'm just gonna go over that and confer with the state.
All right, thank you. Is there anyone else who's ready?
Yes, yeah, that's Ashley's case, she's coming down. Okay.
Yeah.
Perfect. Yes, so what's up?
Last time we spoke, I asked him to talk to my mom about it.
Yes, we did talk to her. He didn't like it being as low as two. Just wanted to
No, thank you.
do that. We can do it. He's still wanting to come in and with the kid and testify.
Yeah.
So
All right, just give me one moment.
5, or if he's got another number in between 2 and 5, let me know.
And is Jorge Torres on the docket today?
No, dude, I'm not gonna.
Hey,
Yeah.
let me call the mom again and you'll get it done today, all right?
Okay.
I'm not sure if she if I should do that now. Yes, don't, hold on, she don't know it. I've got a lot of.
Right, you say page 6? Miguel Alatorre. Is it Miguel Alatorre? Okay, and you say page 6?
Printing,
Okay. All right, is Miguel Alatorre here? All right, let me know when she's back. All right, who else? Jose Calderon?
We're pressing Judge.
All right,
We approached.
yes.
I spoke to the.
Oh, and I'm sorry, you're on this side and your client is here.
Issues on some videos.
Mm-hmm.
We discussed it this morning. We're gonna email each other back and forth. Find out which ones they are after 2 months. This one? The tail end of it, yeah.
And how old are you, sir?
I didn't get it.
29. All right. Ms. Ferguson?
Yes.
I need a 30-day reset.
December 18th.
All right, we'll be back on December 18th. That will be for discovery and state. On that case, you'll need to be prepared to tender an offer.
Yes, Judge.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court. You're welcome.
Yes, when he gets here.
Who is it?
I'll look you.
Yes, I did. And the middle name is Zulika. Yes. Let me check just 1 second. Because sometimes Odyssey gets things a little bit off. Yeah, she's set. She actually has a warrant.
Oh, great. Okay.
Mhm.
Because it's a real old thing, it's got the same things, it's not like we can things. After that, one of the previous issue, should pick up another case. That's really.
Mhm. Mhm. Okay. All right, so she's in custody in Live Oak. Norma? On page 3, Juliana Guzman, she's in custody in Live Oak. Let's recall this for December 18th and see if you can have her appear by Zoom. Mhm.
So this could be a missing piece that I want to. Of our case,
Okay.
but not need it. She goes to PDC.
Okay, so on this case, if you make sure that you have the discovery from the state and see if they can tender an offer. Okay.
No,
Yeah. Yes, my understanding, she's in custody. Yeah, if you can find out if they will do Zoom there. And if they don't, then we'll need to bench warrant her here. Just have, has she left for TDC? All right, so see if, call them today then and see if they can put her on Zoom.
Okay.
All right, if you'll just give us a few minutes. And let me know if there's if I need to call the jail over there. We'll see we'll see if we can get her in today. Anyone else ready?
Yes and no. You weren't allowed to have board email.
Oh, Norma, Jonathan Carter is supposed to be reset.
Thank you.
Okay.
To confer with you on that. No. For,
Oh, sorry.
and then Judge said that you need to look at this for the application.
Okay. Let me just log in.
Yeah.
Sorry, CPS records. I think you did it last time, but I'm not sure. Y'all were gonna check on the juvenile record. You were gonna make it awesome.
Let's see. String. We have somebody up here, do not talk to them, it has to affect. Yeah.
Awesome, thanks.
So I thought I put her, because you just put her right there. Should be in Sarah Gonzalez. No. No. I guess so. I don't know. I think it's in a set.
Yes.
He wants to approach on the Widener, it's on page 1, second down.
Okay.
The status update on that.
Okay.
He hasn't been brought out yet, Judge. I can wait
Okay.
for him. if you
All
want.
right. I'm Odyssey is slow today.
Okay, no worries.
All right. What is the issue with the competency?
Well, he's scheduled December 17th in the magistrate court for I think it was an update on that, but you wanted just to bring us back to check on the status of it. His competency eval, I think, was scheduled for November 7th. And so I haven't received a report yet. I just checked with court and clerk's office and Norma, and they don't have a report either. So I would assume it's still pending.
Just 1 second. Let me look at something. All right. So you said the competency evaluation was completed on November.
That's when it was scheduled, November 7th.
Okay. And then when is your next date?
So I have a date in magistrate court, December 17th.
All right. So what we'll do is we'll recall this back on the 18th. But if you go there on the 17th and you discover he's incompetent, then we can change the date.
Okay, sounds good. Yeah, if there's any answer to that on that day, I'll come right back. Thank you, Judge.
Is this in it?
I didn't want to, no, but that's what I wanted. I didn't want to grab it without your permission.
Your defendant hasn't signed it and you haven't.
Yes, and that's what I.
Okay.
I didn't want to grab it.
No, I understand.
Good morning. We did, oh, yes, ma'am.
We need to approach.
I should, yes, I do, thank you.
Thank you.
And then you guys might be in the middle of other stuff.
Okay, no, that's fine.
Thank you. We'll see you at 1:30.
All right, see you then.
I'm sending the request right now, sir.
All right, thank you.
Judge, whenever you are ready, I have one.
All right, thank you.
Yes, sir.
All right, I'm ready.
Yes, ma'am. Rios, Edward, page 2-3 down.
Edward Manuel Rios. Good morning.
Good morning, Adam.
All right, so thank you for dressing appropriately for court.
Yes, ma'am.
All right, so where are we on discovery?
Judge, I believe all the discovery has been tendered. I did not make an offer at this setting just because I need additional time to speak with the complainants in the case. And I will be prepared to make an offer at the next setting.
All right, Ms. Ferguson, I need a 30-day reset.
December 18th.
All right, once you sign the reset form, you'll be excused.
There's one other thing that I put on the note, Your Honor, that I'd like to address for the court,
Yes,
which is the GPS.
all
That
right.
he's had, and I did file a motion way back in
All
April
right, could I see the motion for GPS? And what are you going to be requesting with regards to the GPS?
for two things. One, waive fees, and two, just that it be removed. He's had no violations on it. He doesn't have any criminal history. And I did confer with the state about it also. I did actually confer with it previously several times, but we also addressed it today.
All right, and state, are you going to be objecting to the removal?
To the removal, yes, the state's position at this time is that we are amenable to agree to a curfew to allow the defendant to address, I guess, the concerns or the hardship that he's expressed to counsel.
And Judge, I
Alright.
would like to, I'm sorry.
What are the issues
I prefer
with
to,
the GPS?
I would love to go into that, Your Honor. I just prefer to do it off of social
Wait, is it-
media.
Is it like he has to work?
No, it's more, it's deeper than that, Your Honor.
So is the curfew not going to be,
It's part of the work, but it's also the care that he has for an 8-year-old, that he's the sole provider for an 8-year-old, and I can go into why he's the sole provider. I
Alright,
just prefer
so
to do
here's my
that.
question. Do you state, do you have objection to tracking?
Judge, at this time, we would just request the curfew. I think that would be able to address the concerns.
All right, if y'all want a hearing, I'll give you a hearing. Otherwise, I'll agree to a curfew with hours and you all figure out what hours that will address his issues. Otherwise, we can have a hearing. I will hear whatever issues you all want to address.
If the court wants to do tracking for now, I guess we can do that for now, Your Honor, and then reassess
The
it.
state is not agreement with tracking, their agreement with curfew. And what I can tell you, sir, is this is what I do. Number one, I'm not the one who put GPS on you. That's a magistrate judge who did that. Now, the magistrate judges, when they place GPS on you, they've heard some information about your case. I haven't seen any police reports or anything about your case. The only thing I know is what's on the docket and what you're charged with, right? So obviously they heard some issues about your case and they decided that GPS was appropriate. So in my court, there may be some cases where sometime I'm like, I don't understand why they would put GPS on this type of case. But again, they probably heard some issues that I haven't heard. So what I usually do in my court, if, of course, I keep an open mind about everything, but usually if somebody's been on GPS, the next phase I'll do is I'll do curfew, and then the next phase tracking only, and then the next phase maybe removal. But if you all want to present me with some evidence, and I will tell you, the state will probably want me to review a police report or something for me to make a decision on whether or not GPS should be removed, I'll do that. It's completely up to you all.
What I would confer with him about it, Your Honor, but what I would suggest is, if we're not gonna have that hearing today, maybe we'll just agree on some sort of curfew with, but.
Oh, we
with
can
the
have a hearing today, but the state is saying that they will agree to a curfew. So you tell them what the hours are, and that's just what it is. It's a curfew. And so, for example, for your employment, you tell them what your employment hours and they'll set the curfew. If there's some other issue with custody or anything like that, you tell them what the hours are and that will be your curfew. And what I can tell you in this court, anytime there is a violation of pretrial services, the conditions you have with pretrial, normally that will come to me. The only time it doesn't come to me first, if it's some kind of emergency and it's after hours, like it's at midnight, because the courthouse is not open at midnight, then it will go to a magistrate that's on duty. And let me just tell you what those emergencies usually are. Somebody has cut off their monitor. And usually with that, they try calling the person who's on a monitor first before they issue the warrant. And then ultimately what ends up happening, even if they issue a warrant, I still have the chance to overrule that if we determine something unexpected happened, okay? All right, thank you.
So she said for discovery?
Yes, discovering the state to tender an offer. And Mr. Rios, Mr. Rios,
Yes, ma'am.
just remain in courtroom until you sign the reset form, okay?
Okay.
All right, thank you.
If we decide to have a hearing, you said we can have it today?
Yeah, if you want to have a hearing.
Okay. I would,
Can I just do it?
but I would make one request. If there's gonna be sensitive matters that I would prefer
Sure.
not to be on social media.
And let me ask you this. So here's the thing. Anyone else ready?
Like page 8, first one down, Hutch.
And have they finished with their plea? Newman, they were doing plea.
No, I just got paperwork for Rodriguez.
Okay. Norma Olivia. Hello,
Good morning, Judge.
good morning.
The DA has approved, Miss Olivia for, PTD.
Okay.
So,
Pronounce your last name.
There's an extra I in it.
Oh, okay.
yeah, that's what, yeah, I was thrown off by that too.
Thank you so much for dressing appropriately for court. I really do appreciate that.
Sure.
All right, Ms. Ferguson, I need a PTD date.
I can do December 18th.
All right, so it's gonna be set for December 18th. Council, if you make sure that everything is filed today.
Yes.
All right, once you sign the reset form, you are excused.
Thank you.
Make sure you follow through on everything that they're asking of you, okay?
Yes, sir.
Thank you.
The trial courts are.
Who else is ready?
Second case on.
Page 8, third one down, David Crenshaw.
David Crenshaw.
And there's two attorneys on this.
All righty.
Morning, Judge.
Morning.
Judge, Mr. Crenshaw has two. I was appointed to a evading with a prior. It's a
Mhm.
felony, but Mr. Crenshaw also has several second-degree felonies that are
Yes.
slightly more recent and were appointed to Mr. Garcia.
That are awaiting indictment.
Okay.
So I conferred with the cases in totality. I don't know how the court wants us to proceed at this point.
All right. And do y'all have the evidence or discovery?
I have the discovery on my particular case, but not
On
on
mine,
mine.
there. Something we're gonna have to have a hearing on either in front of Judge Nakata or here,
Okay, a hearing for,
suppression
oh, on the unindicted matters?
and the unindicted matters, yes.
Okay.
It doesn't matter.
Judge, I don't know if it makes more sense to appoint all the cases to Mr. Garcia. He is on the higher cases, as he'll probably drive the bus with regards to plea bargain,
Well, I don't know. It depends on what happens to the other cases.
and that is true.
All right. So you have all the discovery?
On the one case, yes.
All right. All right. And and the state, you said wasn't prepared to tender an offer?
She's like,
Right now, the files aren't here, but in our system, but one of them is those 4 to 400 and it doesn't reflect the council dollars.
All right, Ms. Ferguson,
Yes.
recall this on February 18th and we'll see where we are. I'm sorry, not February 18th, December 18th.
Yes.
And we'll see where we are in all matters. All right, thank
Thank
you.
you.
Do you have any questions about anything?
Monique,
All right, thank you.
thank you.
He has a discovery.
Just put it as a status because he has new outstanding cases. And what I can tell you all, that 4 to 400 gram case, if they don't have their labs ready, they don't have their labs ready, your case will continue to move on. And I don't, you may want to ask the state if they can expedite that. All right, thank you.
okay, thank you.
Thank you, Judge.
You're welcome.
He'll come see you. Be there sometime this week. Right? Oscar, those are, my name is David Garcia.
All right, who else?
Um, on page 3, fourth one down. Alani Sarapete.
All right, who is here on Jesus Alanis?
Morning, Judge, Madam President.
Thank you. Are you ready to proceed?
Judge, I'm waiting on an interpreter. It's gonna be a recent, Judge.
Okay. All
Yes,
right,
Your Honor.
all right, thank
Sorry,
you.
Judge. Page 7, seventh one down, please.
Serenity Avalos. All right.
Good morning, Judge. I spoke with her yesterday.
Mhm.
She knew about being here today. She's not responding to my texts, either phone numbers. So, but I just learned this morning, she does have a warrant out of County Court 8 on a misdemeanor theft.
Okay. All right, the court is calling 2025 CR 013231 State versus Serenity Avalos. Can I have parties announced?
Those are for the state. Alma Benavides for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 10:49 a.m. The defendant has failed to answer docket. Deputy Laura, did you make an announcement?
Yes, Your Honor, I did. She sat out there.
All right, defense, have you had any contact?
Your Honor, I had contact with her yesterday, but not today.
All right, state.
And we'll be requesting a bond for her at this time.
All right, the court will issue a judge's warrant, remand your client without bond. All right, thank you.
Thank you, Judge.
All right, what was that previous case, Yaya? It was Alanis, correct? Are you ready on Alanis? All right, this is family violence. Right, today is plea deadline date,
It is, Your Honor.
and is an agreement been reached or no?
No, there has not, Judge.
All right, how long do y'all expect this trial to last?
3 days.
All right, if y'all will confer with Ms. Ferguson on a jury trial date and Mr. Alanis, your jury trial date is probably going to be in the new year because we already have murder trials that are scheduled at the beginning of December. And as you know, the holidays are upon us, so the court is closed on Christmas. We have Thanksgiving. So the earliest we'll be able to take you is probably in the new year. Do you have any questions?
That works.
No. All right, what date?
January 27th, Judge.
All right, and if you all can make sure that the discovery acknowledgement has been signed.
Yes, Your Honor.
All right, thank you. And counsel,
Yes,
I
Judge.
know you'll see about his clothing.
Yes, Your Honor.
They have new policies now at the jail.
Okay.
You have to, I think, let them know within 72 hours.
Yes.
Okay,
Okay, thank you, Judge.
you're welcome. Do you have it? Yes,
So we do have an agreement, Your Honor, that we agree with the state. We're asking the court to
okay.
sign off on it. Oh, did it say waive fees on there, Your Honor? I don't know if it does, but if we,
Put it on there, it's fine. Oh, it does. So let me put it in the system. What is the IT issue?
know the video is not playing.
All right, could you all have Robert Maurer come down?
They checked it for the other videos are playing. There's this one specific.
Okay, we've had to address that before, so I know what we all need to do. And could you call IT to come down? In state, this curfew on Mr. Rios, that's Monday through Sunday, correct? All right, and I'm just gonna write in Monday through Sunday because sometimes pretrial,
Database clear.
there's different things. All right. No, that's jury trial.
Jury trial.
Rios, what page is he on?
Mr. Ballard's client. Daniel Ballard.
Oh, no, let me find it. Just 1 second.
On page,
I want to, sorry, which page?
Page 2.
I want to say that's an offer that's due. Let me just double check. It's for discovery and offer due.
Okay, thank you.
All right, anyone else ready?
She has to be better. I'm working on a plea judge for one of them, and the other one's being brought up from the back, or needs to be brought. And I gotta do the thing.
All right, thank you. And state, so they're gonna call down IT, and I don't think Robert will have any objection to IT going back and just showing them how to work the equipment. But I'm waiting for Robert. Yes. Oh, they have a question. Yeah.
Winning.
I would say no.
So, Robert and Megan. All right, anyone else ready? Like, page 2. 6 on the bottom there. And Farias. Amanda Farias. Morning, Judge. Good morning. How's it going today? Good, how are you? I cannot complain. I don't know. I don't know when we're gonna get real fall weather. I guess it's not gonna happen.
That would be cool.
Probably
though.
like December. It's winter.
Mhm.
They're not.
And I'm just waiting for Odyssey.
At least we're getting rain.
But is that really a good thing? Yeah.
They're like, we can't do fall, best we can do is humidity.
Yeah. Thank you for dressing appropriately for court. I appreciate that. All right, on this case, where are we on discovery?
There's potentially some surveillance footage that might exist that we need to reach out to witnesses on to see if it does exist and if it does, can see it to us. If it doesn't exist, I'll let defense know that. And otherwise, I think that I've disclosed everything else that is about the case to defense.
All right, and were you able to tender an offer?
did.
All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date. All right. At that time, you'll need to let me know whether or not you've reached an agreement. Of course, if for some reason there's a video that's in existence and the state doesn't have it and your counsel doesn't have it, we'll change that, okay?
Thank you, Judge.
All right, thank you. Once you sign the reset form, you're excused. Who's next? Anyone else ready? Other than the people who are waiting on their plea paperwork? Yes, come forward.
Oh, okay.
Okay,
Look at the back.
all right.
Having a
So-
good time back there.
So you need to talk to her, right?
No, we're good. I had a projection on things and,
Okay, so do you want to move forward with the bond issue?
no, I think we're gonna be able to resolve the pending motion.
All right, so if you'll let Yaya know that you are gonna do it so she can pull the documents that I need.
Okay. For the MTR?
Yes.
It's ready, Judge. We're just waiting for this to come.
All right, Lorenza Rodriguez. And Norman, let me know when IT is here.
Yes.
Let them know, they're not to go into the jury room until we're all there. Good morning. All right, and there are no applications?
They're not. Your Honor.
Court is calling 2025 CR 0134228-02, State versus Lorenza Rodriguez. Can I have parties announced?
Roberto Ambrosino for the defense.
And are you Ms. Rodriguez? Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Rodriguez, did you review the true bill of indictment with your attorney? Did you understand it? All right, so I'm gonna need you to speak up so I can hear and the court reporter can hear. Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Rodriguez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to go to trial. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
No.
I'm sorry?
Yes.
All right, so here's the thing.
You good with it?
Yes.
I need you to listen to my questions. I need you to speak up because I can't hear you.
Okay.
The court reporter can't hear you. You understand?
Yes, ma'am.
All right. Has anyone promised you anything other than the plea bargain agreement?
Yes.
What have you been promised other than what this plea bargain agreement is?
Oh, no. Nancy, no.
All right. A little bit, and then you all can come back up, okay? And I'll take you right back up.
Okay.
Anyone else ready?
Bring it up to you, book it. The link, yeah, yeah. Sign me on. Did you sign in?
All right, we're back on the record in 2025 CR 0134282. State versus Lorenza Rodriguez. All right, Ms. Rodriguez, has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
If you're not a US citizen, by entering this plea, you will be deported and denied naturalization and reentry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 85 days in the Bexar County Jail under 1244. There's an $800 fine. There's restitution of $2,817.58 to the city of San Antonio. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There have not.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Your first state's exhibit 1 in all of that.
No objection.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places? I cannot hear you.
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
My client deeply regrets her mistake and we ask him to follow through that.
All right, why are you not walking on the sidewalk?
Well, because I was crossing the street and I know I shouldn't have done it, but was no about being.
Well, here's the thing. You're saying that you were crossing the street, but what you stipulated to, it wasn't that you were crossing the street. It says that you were not on a sidewalk and sidewalks were provided.
Yeah, but I was crossing the street. I was waiting for them to pass.
All right, were you crossing at a cross point or were you crossing in the middle of the street? No what?
No, I was walking across the street.
All right, so here's the thing. When people are crossing the street, there's a light, right? And you're supposed to cross where that light is, not in the middle of the roadway. So my question is, were you crossing in the middle of a roadway or at a light?
Roadway.
All right, so that's not allowed. And if you would have been hit, it would have been, oh, well, because you're not at a light or a crosswalk. You understand?
Yes, ma'am.
All right, the court is going to follow your agreement, find you guilty, sentence you to 85 days in the Bear County Jail under 1244. Give you credit for any time served, an $800 fine. Time and money will run concurrently. There's to be restitution to the city of San Antonio. In the amount of $2,817.58. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, make better decisions, okay?
Yes, ma'am.
All right, good luck to you.
Okay, thank you.
You're welcome.
Thank you, Your Honor.
All right, who is here on Savannah Gutierrez?
Savannah.
All right, the court is calling 2021 CR 7257A, State versus Savannah Page Gutierrez. Could I have parties announced for the record for the state? Defense?
Good morning, Your Honor. Mary Peterzak for the defense. We're ready to proceed.
All right, and are you Savannah Page Gutierrez? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Savannah Page Gutierrez who was placed on deferred adjudication in 2021 CR 7257A for the offense of burglary of a habitation on December 2nd, 2021 for a period of 4 years? Is that you? All right, state. Sure.
I'm sorry, do you have a copy of the statement?
Oh, yes. There.
Oh.
All right, I'm ready to proceed.
All right, state.
Violation of condition number 2 on or about the 19th day of June 2025 in Missouri County, Texas, the defendant Savannah Page Gutierrez did then and there fail to submit to the drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Sure.
And then violation of condition number 2 on or about the 30th day of September 2025 in Bear County, Texas, the defendant began to take Gutierrez did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
Waiting again in early.
Any objection to the waivers?
No, Your Honor.
Did you understand by pleading true to violations 2 and 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violations 2 and 2? All right, is there a proposed agreement?
Judge, what agreement is for the court to deny the state's motion and alter and amend the conditions to include a no harmful or injurious contact order with Angelina Longoria and permit the defendant to buy out her community service hours at $7.25 per hour for community service before it expires.
All right, we can go off the record.
When the court wants the warrant and everything has received all of the previous technical violations that have already been worked through and counseled, kind of appear on there.
Okay, all right. Ms. Abrams, so the 2 and 2 that she's pled true to, that's already previously been addressed?
So, on the first number 2, the June 19th, she submitted a negative urine test on, June 27th. And then and then a subsequent negative on July 22nd. The September 30th was not addressed. We don't have anything after July 22nd. But I can say there have been a few failure to submits, but overall, there have been more negative urine tests than anything, than failure to submits. If that makes sense.
And
And Your Honor, at my direction, she did get a drug test last week as well, that came back negative.
okay. And then who is Angelina Longoria?
Her spouse.
I'm sorry.
So Judge, Angelina Longoria is the co-defendant in the case, and she is also on probation. However, they are legally married, and back in July, a compliance hearing was conducted, and we amended conditions for her to include a no harmful or injurious contact with Savannah Gutierrez, and she could not live in the household with Ms. Gutierrez. At the time, I don't believe the court was aware that Ms. Gutierrez, or it didn't come out that she was also on probation, or the court was not reminded that she was also on probation and had the no contact. So when the supplemental report was sent in, the no contact, the no harmful or injurious contact that had been amended on the other party, was not even mentioned in the supplemental report. So it made it seem that they were just having contact with the no contact order still in place, which it was, but it had been amended on the other party.
Okay.
So, the supplemental report gave direction for an MTR to be filed. And when the MTR was filed, they included these technical violations. Ms. Gutierrez was the court indicated if she finished her trade school that she would be given credit for community service hours. She did not finish the trade school, hence the 95 hours are still outstanding. All of the fees and everything has been paid on the case, and she's been overall compliant with these issues. So probation stance at this point is to allow her no harmful or injurious contact with her spouse, and to buy out the community service hours. Her case is set to expire on the 1st of December.
Okay. So you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, why are you not taking your drug test at the scheduled time on the scheduled date? This whole thing about doing it after the fact, that's not good.
I just work Monday through Saturday, 9 to 3, so.
All right, so why, did you pick up the phone and tell your probation officer that? Probation, has she been telling them that she works?
Judge, one moment, I can look. Judge, I don't have, a quick way to look at that. If you would like Mr. Marino to zoom in, I can have him zoom in, Judge.
No, that's fine. Oh, no, he doesn't have to zoom in. All right, so here's the thing. In this court, communication is key. That's the only way you're going to successfully complete probation. I tell people all the time, if there's an issue, you need to let your officer know about it. If you feel they're not addressing it, you come to me and we address it. You understand? All right, this is what the court will do. The court will follow your agreement to deny the motion. Alternate main conditions, I'm going to extend her for 2 months. Those 2 months, you had better make every UA and do everything. You understand? And probation, she can do the UA or she can do the patch. It seems like she may be able to afford the patch. There is to be no harmful or injurious contact with Angelina Longoria. You're going to have to complete those remaining 95 hours of community service restitution, or you can pay it off at $7.25 per hour. Usually I say make a donation to the food bank because usually the food bank, they're always low on items for people. So if she wants to make a donation to the food bank that equals the $7.25 per hour, she can do that. All right, is there anything else? Probation?
Judge, as far as the UAs are concerned, with the extension of 2 months, typically we just do monthly. Are you asking for just monthly?
Yes, or she can do the patch.
Okay.
Is there anything else?
Just the patch.
The patch is approximately 300. But the patch costs more, but it helps you with your time.
Yes.
All right. All right, don't come back again for this, you understand? I'll keep an open mind, but I'm telling you, don't come back for it. All right, good luck to you.
And Judge, I just want to make sure that we are perfectly clear on the amended conditions for the other case. It says they cannot live together. Is that still the case?
Yes.
Okay, still the case. Okay.
Thank you, Your Honor. That
And
was my case.
as you know, there are reasons why I said that you all could not live together because there were issues. You understand?
Yes.
All right, State, do y'all have your, you're excused and the warrant is recalled?
Is there any other paperwork that she needs to fill out?
No.
Okay.
All right, and State, do y'all have the computer that's? Okay, all right, thank you. Anyone else ready?
Yes, ma'am. Page 11, read down, largest.
Is that an MTR?
No, it's a motion to set bond, Judge. I'm an MTR, yes.
All right, have y'all conferred on the actual allegations that are in the motion to revoke?
No.
Do y'all want to do that?
I'm sorry.
Do you want to confer on the actual allegations in the motion? I don't know what's in the motion.
I've looked at it, but it's not on the docket for an MTR. I don't know
All right, if
Sean
y'all
can
want
get
to
the.
pull it so you all can look at it, maybe you all can work something out. If not, I'll hear your motion.
Judge, I think we're gonna need a contested, it's a defense of due diligence, so.
Ah, okay. All right, where's your client?
He's Spectre.
All right, wait, so bring him out, we'll take him out.
That, by the way, is his own defense.
Okay,
Doubt we're gonna.
You have, Judge.
yeah,
First is yours.
okay. All right, who's ready?
Yeah, Mr. Vargas, here you are.
All right. Court is calling 2019. I'm sorry. And does anybody have a copy of the motion to revoke on this?
Was one in the file, Judge.
Jonathan Vargas. Oh, we don't have files anymore.
Oh,
So all I have is your motion.
oh, you do have it. Oh.
Yeah, I have the motion. I'm talking about the motion to revoke.
Oh, I'm sorry, I'm
Yes.
sorry.
All right, Judge, I haven't taken care of it. Give me just a moment.
Oh, do you have it? All right, the court is calling 2019 CR 8713 State versus Jonathan Vargas. Mr. Vargas, if you'll come down. Can I have parties announced for the record?
Attorney for the state of Texas. John Paul, Your Honor, on behalf of Mr. Vargas.
And are you Mr. Vargas?
Yes, ma'am.
All right, defense has filed a motion to set bond. The defendant is on deferred adjudication. He is entitled to a bond. Of course, there are exceptions to that. So have you all agreed on a bond amount or no?
We have not. The state has made a recommendation of 20,000, Judge. I would like the court to take into consideration that Mr. Vargas has been on basically 2 years probation for 6 years. And that he has now turned himself in voluntarily, surrendered himself. He wants to get this thing behind him. So he's certainly going to show up for court. I just think 20,000 might be a bit excessive.
All right, so he's probation for 4 years because he was on probation for 2 years, extended for a total of 2.
Yes, sure.
All right, so you want to call somebody to present evidence on the bond that is appropriate?
Your Honor, I'd be happy to call my client.
All right, Mr. Vargas, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Jonathan Vargas.
All right, defense, you may proceed.
Mr. Vargas, are you married? Do you have a child?
Yes, I have 6.
I'm sorry,
I have 6 children.
6 children. And is the mother of one of those children, do you live with her?
Yes,
Okay. What is her name?
Gabriella.
Okay, and what do you do for a living?
I have a business. I mow lawns. It's called Loyalty Lawn. And I take care of my child, Elias.
Okay.
And Julian. Well,
Okay, and then what does his mother do for a living?
she works for CBS. I don't know the right term she does, but she works. She works for CBS. I don't know the right term.
Okay. CBS
Yeah, CVS
pharmacy.
Pharmacy.
Okay, and does what kind of resources do y'all have in terms of money?
She works with CVS. I cut lawns. My family helps me out. If I ask them for help.
Okay.
Make money for my family.
Okay, but in terms of like right now, do y'all have any savings?
Not at all.
Do you have a vehicle?
Yeah,
Is it paid off? Does how many vehicles do y'all have?
just one.
Just one between the two.
Yes,
And then you also take care of your child, correct?
yes,
Are you,
That's-
when she goes to work, are you the full-time
yes.
caregiver for that child? And I'm sorry, do you have any other resources financially besides I guess your income from mowing lawns is kind of
Yes.
sporadic, is that right?
Yes, it is.
Okay.
Correct.
And then her full-time income is, she works full-time for CBS.
Yes.
And besides those, how much does she make?
Month, I would say. About 2,000.
2,000 a month? Okay. And how much would you estimate you make monthly from her lawn care?
$500.
$500 a month. Okay. So very sporadic.
Yeah.
Okay. And do you have the ability to make a $20,000 bond? Right now?
Oh, no, I don't.
Okay.
No.
Do you have the ability, would you have the ability to make a $10,000 bond?
Yes.
Pass witness, Judge.
Yes.
Question. Report, if you got your own landscaping business and you said workers for that for,
Yes.
so how often would you say?
Excuse me, just a second. I'm sorry. That's okay. You continue.
So how often would you say you get jobs for? A monthly basis?
On a monthly basis?
How many jobs would you say you would on average?
6.
6 months?
Yes.
Okay. You said you're getting 6 children, right?
Yes.
Are they all with the same mother?
No.
How many, I guess, mothers are?
I have
there for 6
5
children?
mothers and 6 children.
5 mothers.
5
and 6 children.
yes.
Okay. Do all 6 children reside with them?
No, they don't. Only 2.
2.
Yes.
And where are the other 4 reside?
With their mother.
Two.
With their mother. Yeah, they have different mothers.
So each mother has a, I guess.
Yes.
Okay, thanks.
Uh-huh.
And, okay, your wife worked at CVS?
Mhm.
Is she a pharmacist or is she just like a cashier?
No, she works on the computer. She don't do neither of those. I guess she does like data.
Okay, you said she makes 2,000 a month?
Yes.
Okay. You said you got family support, correct? Other
Correct.
than your wife?
Correct.
Who in your family would be able to help support you financially?
Let's see, my grandmother, my mother, my stepdad, my mother-in-law, my father-in-law.
And your in-law?
Yes, I have a really good family support.
Does your grandmother work?
Yes,
Where's she from?
she's actually in this room.
She's what?
She's actually in this
Oh, I understand. Okay, to me,
room.
she's just a little.
She works for a doctor. She works at, I don't know if I know the name, but she works for a doctor.
She like
She's a medical assistant, yes.
Okay, and what about your mother? What does she do for?
She,
Or is she employed?
yes, she is.
And what does she do?
I'm not quite sure, but
And your stepfather, is he employed?
yes,
What does he do?
he has his own business as well. He does
What kind of business?
free, he makes logos, I guess.
Logos?
Yes.
Okay.
I don't know the right term for it, but
And then your mother and your father-in-law, are they employed?
yes,
What do they do?
a teacher. Another one works for Sony.
Is it your mother-in-law that's a teacher? Or your
Yes, mother-in-law.
Mother-in-law's a teacher and your father works for Sony? Or
Yes.
father-in-law? Do you have any estimation as to each of those persons' monthly income?
I don't.
All right, thank you. This is what the court is going to do. The court is going to set your bond at $10,000. There's to be no contact with the complainant. There's to be random UAs. The court will waive fees. This is going to be set for a contested hearing on December 9th.
And Judge,
All right, has he been on have you been on GPS?
No, ma'am.
All right, what is the purpose of GPS?
Given the fact that the warrant was 2 years old and it took him 2 years to address
well, Judge, that it took the state 2 years to address that, and that's, I think, what we'll take up at the actual contested hearing, but it's the state's duty to go out. He wasn't hiding from them. He wasn't actively hiding. They just didn't exercise due diligence.
All right, so it's going to be partial GPS for employment and the fees will be waived.
I'm sorry, what, I didn't hear.
Partial GPS for employment and the
Oh, so when
fees,
he's out,
and the fees will be waived. No, they'll give him a GPS before he's released from custody.
but his employment is like landscaping, so it's.
Yes,
Great.
he's allowed to do that.
Okay. And
All
then,
right.
Judge, I also wanted to ask, on the
Yes.
no contact order, that's his, the,
Doesn't
victim in
he
the
already
case is,
have a no contact order with the complainant?
no. He lives with her.
All right, so we need to check that, but your contested hearing is gonna be for December 9th. If I can get a reset form for December 9th for a contested hearing, please.
Thank you, Judge.
All right, step aside. They'll see if there's a no contact order that's in place.
Okay.
If there's not a no contact order, then there will not be a no contact order now unless there's some information that is presented to the court. Oh, that there should be. All
Thank
right,
you.
thank you.
Thank you.
Christopher Mendez. Court is calling 2025 CR 014524 State versus Christopher Mendez. Can I have parties announced for the record for the state? Defense,
Christian Newman on behalf of Mr. Mendez.
and where's Mr. Mendez?
He's coming.
Are you Mr. Mendez? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Mendez, did you review what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes.
With your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, do you have a right to have a grand jury indict this case and make a decision on whether or not there's sufficient evidence to hold you over for trial? You also have a right for your attorney to have 2 days pass once they're presented with the information and 10 days to prepare for trial. Did you understand? By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Court will find that the defendant has knowingly and voluntarily waived indictment, reading of information and rights under 51 and 26.03 of the Code of Criminal Procedure. Did you review the information with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the information?
We do, Your Honor.
State you're proceeding on the information as presented.
Yes, sir.
Mr. Mendez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
You're charged with unlawful. That's a 3rd degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering that plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Mendez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine, no applications. This will run concurrent with 2020 CR 2487. State will take in consideration 2025 PF 37392, 37393, 37395. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Not in this case, Your Honor.
Then to the offenses filed, how do you plead? Guilty, not guilty, or no concept test?
Guilty.
State any evidence?
It offers states one.
Any objections?
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept in the evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, but I do have a request in that regard, Your Honor.
Yes,
And it's concurrent with disposition of the MTR.
yes.
As the court is no doubt aware, the last legislative session amended the Code of Criminal Procedure, Articles 27.20,
Yes,
concerning the necessity for confinement upon plea of guilty or no contest.
yes.
I've submitted written briefing to the court that I filed just yesterday afternoon in support of the request for allowing self-surrender of Mr. Mendez. In my reading of 2720, it appears that the mandate, the shall, concerns offenses enumerated under Article 42A.054, or what we call our 3G offenses. Mr. Mendez's probation, as well as the new case that he's pleading to today, are non-3G offenses. I'd submit to the court that Mr. Mendez has been strictly compliant with the conditions of bond in this case. He self-surrendered promptly when an MTR was triggered by his new arrest. He's been to court, he's been reporting, he's been compliant with conditions imposed as part of his bond. The ask is that because Mr. Mendez, and it's really a twofold basis for the request, he's a small business owner where he's been diligent. He's in. It's a moving company, a pretty successful one. And 2, he's the father of a 12-year-old. We'd asked for 45 days to allow him to have one more holiday season with his daughter before he goes in to serve his time. I think he's demonstrated a willingness and obedience of the court's orders. And so we'd ask for the court's mercy in granting that request, whether it be a sentence today with self-surrender or reset for sentencing so that the court could expose Mr. Mendez to a fuller range of punishment for a failure to comply. So kind of alternative requests.
All right, Mr. Mendez, you're currently on deferred adjudication for a first-degree felony. So the the request for self-surrender will be denied. The court is, as previously stated, the court is finding you guilty. The court will sentence you to 5 years in the prison. There's a $2,000 fine, time and money to run concurrent. This will run concurrent with 2020 CR 2487. Take in consideration 2025 PF 37392, 37393, 37395, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. All right, let's move on to the motion to revoke. Counsel, did you do a trial court certification on the motion to revoke?
I did, Your Honor.
All right. Court is calling 2020 CR 2487. Could I have parties announced for the record?
Christian Noon for Mr. Mendez.
Mr. Mendez, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that document with your attorney? Did you understand it? Are you the same Christopher Mendez who was placed on community supervision in 2020 CR 2487 for the offense of manufacturing delivery of controlled substance penalty group 1, 4 to 200 grams?
Yes, ma'am.
All right, state.
Violation of condition number one on or about the first day of September 2025 in Bear County, Texas. Not a firearm by a felon in violation of.
How do you plead to that?
And we leave an abandoned or here.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number one, court could find it true, grant the motion, sentence you up to 5 years in the prison and up to a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition number one? All right, court will find violation of condition number one true. Is there a proposed agreement?
There is, Your Honor, it's to grant the state's motion for both the defendant's community supervision and sentence him to this underlying 5 years in prison to run concurrent with the case.
All right, and what was the previous case number?
2025 CR 014524.
All right, but Mr. Mendez, are you asking the court to follow that agreement? Are you waiving your right to appeal? All right, the court will follow your agreement. The court is finding violation of condition number one true. The court will sentence you to 5 years in the prison. This will run concurrent with 2025 CR 014524. There's a $1,500 fine, time and money to run concurrent, and the court will give you credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Mr. Mendez, sometimes, hands are tied, right? But I want to let you know, I do appreciate your turning yourself in. I appreciate your showing up on time, and I appreciate your being dressed appropriately, even probably knowing beforehand that you had worked out an agreement for prison time. I wish you the best, okay? You're welcome. Who else is ready?
May I present the TIC dismissal?
Yes.
Thank you, Judge.
The second seat, Judge. Keep on page 9. 92 down.
Let me put this in my notes on the system, because sometimes things get lost.
Sure. Appreciate it. What time are we starting tomorrow?
Oh, tomorrow?
Yeah.
Oh, noon.
Okay, good.
Thank you.
I'm gonna be in Guadalupe County in the morning, but want to make sure I made it in time.
Oh, thank you.
Thank you, Judge.
All right.
Okay, thank you.
We're gonna try to get him in by Zoom. All right, Lindsay Turiano. And Norma, have you ever already ordered? Well, we'll do this and then we'll take a break.
Sarah.
All right, court is calling 2025 CR 005466 State versus Lindsay Terriano. Do I have parties announced?
The state of Texas.
Brian Kimbrough from Mr. Toriano.
Are you Mr. Terriano?
Yes, Your Honor.
All right, you entered into a plea. According to the plea, punishment is be assessed at a cap of 5 years in the prison. There's a $1,500 fine. The state is opposed to your applications. They're taking in consideration 2025 AL 007223, 2025 CR 010071. There's an affirmative finding of family violence and no contact with the complainant. Have both parties had a chance to review the PSI evaluation in tab?
I have, Your Honor.
Yes, Your Honor.
Any objections?
None from the state.
No objections.
Any witnesses state?
None from the state. No.
Defense, any witnesses?
No, Your Honor, just Mr. Toriano.
All right, do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Lindsay Toriano.
All right, you may proceed.
Thank you. Mr. Toriano, we talked before you came up here today, correct?
Yes, sir.
Earlier today.
Yes, sir.
Okay. And I discussed the pre-sentence report and everything that was in it, correct?
Yes, sir.
Now, in terms of the events, do you accept responsibility for what happened?
Yes, sir.
Was it your fault?
Yes, sir.
Yes, you have been on probation in the past, correct?
Yes, yes, sir.
A number of times.
Yes, sir.
And have you completed all of your probation successfully?
Yes, sir.
I think you had one prior felony probation that you were on, correct?
Yes, sir.
And you completed that.
Yes, sir.
And your misdemeanor probations, you also completed those, correct?
Yes, sir.
Have you ever been to prison?
Never been in prison, sir.
Okay. Were you employed at the time of this event?
Yes.
And how long had you been employed?
8 years.
And do you believe that you could get a job if you were placed on community supervision fairly quickly?
Yes, sir.
Is it your habit to keep employment for a long time or a short time?
For a long time, sir.
Okay. Now you have family support, correct?
Yes, sir. My 87-year-old grandma, she's here.
Okay.
And,
Mother and your uncle are here in court today in support of you, correct?
yes, sir.
And your grandmother is 90, right?
87.
She's 90. Just spoke to her. She's 90 years old and she's here today.
Yes, sir.
And your mother was not able to attend, is that correct?
That's correct.
Because she's in California.
That is correct.
You have a good relationship with her.
Yes.
So you have a lot of support. That's why you think you could succeed on probation?
I can succeed because I want to be there for my grandmother and my family, and I just want to move forward with my life and continue my career as a network technician. So, I apologize for anything that's caused, and apologize to everybody, and I love everybody.
Do you have any substance abuse problems,
No.
drug problems, alcohol problems?
No.
Okay.
Yes, sir.
And you were also contending, or did you attend technical school?
Technical school, 2 years.
And counsel, I'm so sorry to interrupt. This is what I want to know.
Mhm.
Because he's applied for probation on a violation of bond protective order, assault, stalking. I want to know why he won't leave this lady alone, because it appears she doesn't want to be involved with him anymore. So that's what I want an answer for, because we're here because there was a court order in place saying you were not to have any contact with her. The stipulations were that she was out with friends. You all were not together and you followed her. Stipulated to, right? I want to know why he won't abide by court orders.
No, Your Honor. I apologize about that.
No. I don't. I appreciate your apology, but that's not what I need. I'm trying to figure out why because a court has ordered you not to have contact with her. Friends, and you were stalking her, you were following her, you violated the bond, the protective order.
Yes, sir.
I want to know why he's violating the protective order, because that's an order, right?
Yes, sir.
And it says you are not to do certain things. And according to what you stipulated to, you did those certain things. If I were to place you on probation, I'm going to order that you do certain things.
Yes,
So I'm
ma'am.
trying to figure out why you didn't follow the previous order. What do you mean it was a mistake?
Mistake, thought we were talking,
Well-
the reason why I was put it up.
There's an order in place. You're not supposed to do that. Are you saying you didn't know about the order?
I didn't know about it.
All right, so then it's not a order and you started following her. I'm trying to figure out why you're doing that.
I was in love with it.
I'm sorry, what?
I was in love with it, Your Honor.
All right, and how old are you?
43.
All right, you may continue.
And I did want to point out, Judge, that based on the stipulations, I don't dispute what the court's saying. However, there's also, and I reviewed it before coming forward today, that she went to his apartment and it was at his, from the bar to his apartment, and she doesn't indicate that she was forced to go there.
Okay.
So she was there, and then he was there, and of course, he was in violation of the order. Do you believe that you have learned that what you did was wrong?
Yes, yes, sir.
Will a woman or man that you cannot be around them?
Understand.
Will you do it again?
No, sir. No, Your Honor.
Do you believe that part of your motivation was your emotional attachment,
That is correct. Yes, sir.
but now your brain is involved, correct?
Yes.
Your reasoning is involved. Will it happen again?
No, sir.
All right, so this is what it says in the stipulations. Making location, I spoke with victim one who stated that she went out to a local bar with friends. And that is where the original contact with S1, your S1 suspect, occurred. Victim stated that she did not invite or notify the suspect of her location, and the suspect follows and stalks her. Suspect made contact with her and told victim that she needed to go back to his residence to pick up some clothing that belonged to the victim. The victim went to the suspect's location, and victim stated that she got into an argument with the suspect. Victim stated that as she tried to leave his residence, suspect began to make physical contact with victim and bit victim on her right upper arm. Victim attempted to leave the location and rushed down the stairway. Victim stated suspect dragged her up the stairway in an attempt to prevent victim from leaving. This resulted in victim getting bruising on her left leg. Victim stated she then left the location, and that is when she called the police. Those are the stipulations. All right, this is what the court is going to do. Court is going to find you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. Taking consideration 2025 AL 001007. There's affirmative finding of family violence. There's to be no contact with the complainant, and the court will give you credit for any time served. The court will recommend therapeutic mental issues. I'm going to show you what's entitled trial appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, sir.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, so we are off the record. What I can tell you is the complainant no longer wants to be in a relationship with you. when you're released, if you have any items of hers, you know, drop them off at the police station, wherever it may be. You understand?
Move on with my mom. So
Okay.
I just want to go to California.
All right, good luck to you. And counsel, if you remain, state will give you the dismissals.
Oh.
Thank you.
Triano?
Okay.
Okay. Do you have a plea that's ready? Yes.
Yeah, okay. This is the TOC case on that one.
And do you have the others? Oh, that's through the state. Okay.
Thank you, Your Honor.
Yeah. Oh, I'm not doing that. I'm dieting. What page is he on?
He is on, I'm sorry, just page 7 there.
Joe Anthony Garcia. And then after this, we'll take a short break.
Thank you.
Court is calling 2025 CR 013212 State versus Joe Anthony Garcia. Can I have parties announced? For the state? Defense? Garcia?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
The trial court. State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Garcia, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with burglary of a habitation. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Do, Your Honor.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Deputy Moore. Deputy Moore, off the record. Will do. Thank you. All right, we're back on the record. Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Do you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $2,000 fine. State is silent on your application. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and rules upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that you have no contact with the complainant. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation? To the offenses charged, how do you plead?
Guilty.
State, any evidence?
The doctor states one infraction.
To be excused. Did you review this waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We can go. Side, it's going to be 8 to 12 weeks. If you just want a short resets, we can bring it back at the beginning of December and you can have witnesses or whatever evidence you would like presented.
Short one, Your Honor.
All right, Ms. Ferguson, I need a reset date for sentencing.
We can do January 6th.
No, beginning in December.
Oh, beginning of December 10th. December 4th.
All right, December 4th. All right, probation, there's no PSI. Thank you.
Thank you, Judge.
All right, Deputy Laura, we're gonna be taking up Cantu and then everything else will have to come back in the afternoon.
Okay, all right, gentlemen, let's go.
I think was there only one?
There was two, but one of them could have been done by intake. I decided just to do it myself.
All right, thank you.
You're welcome.
Did we? I don't think that.
Sure, I have the right people. Go around the corner. That takes care of one on the hold on.
Oh, my name on it.
That takes care of one.
All right, thank you. Let me do this. And thank you for coming earlier to see where we were.
We have one other one in the hopper, so we're just trying to figure out.
Okay, so if y'all can confirm that, we're gonna take up this case.
No.
I think that we'll see again after the
All right, thank
Judge,
you.
what time you want everyone to come back?
2,
2 o'clock. Can I do it by Zoom, Judge, for plea?
yes.
Can I have a request for a reset
Oh, I can't do that right now.
on Zoom?
Yes,
Does my client have to come back up too?
yes.
So it is.
Your Honor, may we approach quickly?
Yes.
We have an agreed motion to reduce bond. I've already signed the order. I don't know if you would like us.
Judge Nahara, is he on the docket today?
Yes, on the docket, yes, sir.
All right, so you'll have to come back up here for a reset if that's what you're all seeking it too. But the motion.
He was
for
only,
bond-
he was only set for the hearing, Judge. He has a separate setting for.
Oh, well, if you'll take it to Judge Nahara.
Thank you, Judge.
All right,
so
thank
much,
you.
Judge.
You're welcome. And what is the person's name, please?
Liao, Jacob.
All right, thank you. All right, and family violence, if you all will move so that Mr. Bont could have that area, please.
Your Honor, are we gonna get started?
Yes.
Okay, I just wanted to try to have my witnesses ready to go.
Sure.
He's on house arrest. It's for house arrest. He wants to know if it's, but he said he got permission to be at court today, so he just wanted to know if it's okay for him to go home and come back here.
Yes, because they'll have the conditions on there. Prepared? All right. Court is calling 2024 CR 1238. 2024 CR 1237, State versus Erik Nathaniel Cantu. Can I have parties announced for the record?
Melissa Albin and Lauren Espinosa for the state.
Charles Funk and Lindsay Shaw from my client Erik Cantu.
And are you Mr. Cantu? All right. Mr. Cantu, have you had a chance to review the motion to enter adjudication of guilt and revoke community supervision in each of these cause numbers with your attorney? Did you understand it? All right. In each of the Cantu, who was placed on deferred adjudication in cause number 2020-1238 for the offense of evading arrest detention with a vehicle on September 9th, 2024 for a period of 7 years. Is that you? All right, state.
Your Honor, we are going to proceed on the only allegation aimed in the MTR.
All right, would you like to read it into the record?
I will, Your Honor. I'm just trying to find a copy of it. On or about the 28th day of September 2024 in Bexar County, Texas, the defendant Erik Cantu committed the offense of assault in violation of condition number 1.
To that offense, how do you plead? True or not true?
Yeah, it's true.
And that is in both cause numbers?
Right.
All right, did you understand by pleading true to violation of condition number 1 in each cause number, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine? All right, then the court will find violation of condition number 1 true. You may be seated. So, to both parties, the defendant was placed on deferred adjudication on September 9, 2024 for a period of allegation is from September 28th, 2024. We are currently sitting at November 11th, 2025. So the court's question is, this new number 1 that is in the motion to revoke that the defendant has pled true to, why is this just not being brought at this late date? And the court will note that the motion to enter adjudication of guilt was filed on September 23rd, 2025. So you have something where the defendant has pled true from September 28, 2024, and this motion to revoke was just filed on September 23rd, 2025.
Yes, Your Honor.
Yes.
Your Honor, as I have explained, when I was assigned to this court, I reviewed a motion to potentially consider withdrawing Mr. Cantu's GPS. And upon doing so, I observed that he had this unfiled misdemeanor assault that had viability to it. I can't explain why the case sat for as long as it did. I just know that as
and great to be back with you again. But listen, what you're talking about sows a gaping divide in the United States of America, especially as it concerns economic principles. I would say on this day last year, there were exactly 0 people who thought that today, New York City, which had been the headquarters of capitalism through the capital markets, would be governed now by a self-avowed communist and Marxist. Stock exchanges are maybe the epitome of capitalism. You use them to raise capital, to trade capital, to ensure that businesses are going to have the money they need to be able to operate and to grow. And what Mandami stands for is the antithesis of capital and capitalism. At the opposite end of that, Texas is perhaps the greatest example of capitalism in the United States of America. This is one of the reasons why all these companies and all these jobs are choosing to come to Texas in the first place. But a subset of those jobs are the financial sector. The interesting thing is, before Mandami was elected mayor of New York, over the past 5 years or so, Texas has been ranked number 1 in the United States for the most finance sector jobs of any state in the United States, more so than in New York. and especially in the Dallas area, the greater Dallas area, home to so many financial institutions. J.P. Morgan has more finance employees in Texas than New York or any other state. Goldman Sachs is finishing off a 3-tower facility near downtown Dallas, where they will have more employees than any other city in the United States. Charles Schwab moved their headquarters to the Dallas area. We just broke ground a couple of weeks ago on the ribbon cutting, if you would, of a massive new facility for Wells Fargo. The list goes on and on. Scotiabank just moved their North American headquarters to the Dallas area. There's financial institution after financial institution are calling Dallas their home. Then you add to that something that had long been a vision of mine, and that is to. I was visiting with some people about this a couple of years ago, and in the aftermath of that visit, the person who's now running this organization, his name is Jim Lee, he called and asked if I was serious about Texas having its own stock exchange. I said, absolutely. He went to work on it, he has a long experience of working with Wall Street, and he put together all the pieces that needed to be put together to establish the stock exchange, incorporated it, got the approval by the Securities Exchange Commission, and now the Texas Stock Exchange already exists in Dallas, Texas. So what does that do? It sows competition. Inherent in capitalism is competition. Competition makes the marketplace far better.
2024. So when that first MTR was filed and disposed of in December, on December 4th of 2024, we still didn't know that this case existed. So the MTR got disposed of, he got sent to ISF, and then once he is sentenced on his MTR and the MTR is no longer pending, we have no reason to look him up and see what else is going on until he is set on our court date or in court for us. And since the misdemeanor case was an at-large filing, he never got a court date on it. So we were never notified that he had a new case. And to see what's going on with him, because he's already been sentenced on the MTR, and that part has already been closed out.
But this was sitting in your office, you say, since December 2024?
There was the JN was requested by the police department December 18th of 2024. I'm not entirely sure when the case was completely sent over, but that's when the JN was requested. Yes, ma'am.
Defense, do you?
The comment, it was brought to my attention when there was a request made for him to have his GPS removed. And that request was made by the probation department. So the probation department at that time has found that my client has been such a model probationer that on their own, they asked the district attorney's office to review the possibility of removing the GPS monitor. And only at that point did the state then realize, well, no, not only will we not agree to that, we're going to do something completely opposite. We're going to file a motion to revoke his probation. And based on a case that was filed with the district attorney's office, according to the charge and disposition report, December the 18th of 2024. So for the district attorney's office to say, hey, it's not our fault because nobody told us, it's their own office. So what you have is a young man who was placed on probation September of 2024, has pled true to this offense that happened several weeks after, came before this court in October of 2024, and this court took it upon itself to sanction him, send him to ISF, has had him on the monitor since then. And I think what perhaps the most important, or one of the most important things to consider, is how he's done from that point until now. And that's in the court summary, which I certainly hope the court has had a chance to review.
I don't review court summaries until there are no objections. Any objections to the court reviewing the court summary?
No, Your Honor.
And do you have a copy or may I approach and tender a copy to the board?
Usually it's emailed to me, but as I said, I don't look at any of this until both parties have no objection. So let me see my email. All right, I do not have the court summary.
May I approach?
Oh, you know what? Actually, it is here. I'm sorry. It was thank you, Miss Abrams. It was the last attachment. All right, just let me review this. All right, you may proceed.
I certainly think anytime the court is considering a motion to revoke probation, the court should always look to the person that knows the probationer best. And in this particular situation, that would be the probation department, who has, at the direction of this court, made upwards of 11 home visits, monitored him closely, and has made a recommendation to continue, and has justified their recommendation with what I would consider a lengthy justification based on behavior that has shown him to be an individual that when he was before the court in October on the part, went to the ISF. When he was at the ISF, was a model performer there, came out and has learned and performed, frankly, magnificently on probation. So not only do you look at how long ago this was and the fact that the state, for whatever reason, chose not to file the MTR on their own, and then also look at, well, probation, knowing what the new number one is, because clearly they do, but more than Ms. Albin, the probation department knows Mr. Cantu. Knowing what the allegation is, it's still their recommendation to continue him on probation. And they justify this based on his behavior and his performance with the probation department. And I certainly think the court is aware that if probation had a concern about his ability to perform or a concern about his ability to be a good probationer, they would voice it and you would see it in this report. But to the contrary, this might be the most glowing court summary I've seen in quite a while for someone. And I think that's certainly something I hope the court will consider. So I'm certainly concerned that there's this belief that, well, it was filed in December, but nobody told me, so I didn't do anything about it. Well, they're the same office. So, and I guess we should assume that if the probation department had not on their own asked to have the GPS removed, we wouldn't be here, because the left hand is not telling the right hand what's going on. She certainly wouldn't have on her own looked up who Erik Cantu was, and we wouldn't be here at all. We're only here because he was doing so well. They asked her to consider taking the monitor off. That's the only reason we even got here. And if Ms. Albin is concerned that he needs to be prosecuted for this assault, that case is pending. In a misdemeanor court, it's a misdemeanor offense. He has a court date coming up, and he will face facing prosecution on that case. But to ask this court to revoke him for something that happened right after he was placed on probation, and more importantly, before he had the chance to prove to the probation, and more importantly to this honorable court, how he took this court's instructions and concerns to heart, and has proven to the court that he did listen to you that day in October when he was here in 2024. And it's indicative from the report. So I don't see how the court, I hope that the court doesn't justify revocation on something that happened over a year ago, before he had the opportunities the court gave him to improve himself and learn that where, you know, where he was in a bad place, and the court is aware of the trauma that Mr. Cantu was facing then. Certainly, he was the victim of a terrible, terrible situation at the hands of San Antonio Police Department. And I think, you know, I know that the court talked to him about that on that day. They spoke about you and he spoke about it frankly, as I recall. And he took those words to heart. And I think that this justification by the probation department tells the court that he did listen and he is taking probation very seriously. And I just don't believe that it's right for the court at this time to consider revocation for something that the only reason is what we just didn't know it was there, when we know from the charge and disposition report, this thing was filed with the district attorney's office December 18th of 2024. That's not when the JM was requested, that's when the C&D was filed. So their office had it. And just, it's unfortunate. I mean, it's just not, I don't think that's the way things should happen. I disagree with Ms. Allen that there was not an opportunity prior to September of 2025 for anybody to do something, 22nd of 2025. So I'm asking the court to listen to the individuals who know my client the best regarding his probation, and that would be the probation department. I'd ask you to follow their recommendations, continue to monitor. I ask you to read closely the justification they give you for why they're recommending that. And I'd ask you to deny the state's motion to revoke. Thank you.
Thank you.
May I respond to him?
Just a moment. So this is what I want both parties to know. The defendant was placed on deferred adjudication. He came to the court on a motion to revoke. With regards to the motion to revoke, both the state and the defense at that time and probation asked the court not to revoke. They asked the court to deny and give certain conditions. Whenever I set conditions, I'm setting those conditions, hopefully so someone will turn their life around, hopefully so one will succeed. Some people always say my conditions are too many, but I provide people with conditions that are supposed to make them think about the reasons they're here, internalize it, and do better. Now, what I'm looking at, since that motion to revoke has been filed, that the court sentenced him to ISF, he successfully completed it. The court keeps him on GPS, so he's still on GPS. I ordered that he complete parenting class. According to the court summary, he completed that. There was a request for him to take the aggressive driving course. He completed that. The court has placed an order that he's not to drive. I haven't received any information since that first motion to revoke that he is driving. The court ordered him to provide proof of employment, and as both parties know, that's normally no employment as a home healthcare provider or with minors. And based upon what I'm seeing here, he has completed that. And probation is recommending that he not be revoked, that he be continued to be monitored. And the fact that I have this case here and another judge just had me, and it's, I should say justice now, Justice Velia Mesa, asked one of her students to send me questions, sort of an interview, and to answer those questions. And the first question was, how do you as a judge deal with cases where there's publicity involved, right? And I wanted to send them a simple answer, but then I'm like, they probably wanted more detail about the judicial canons of ethics and all of that. But for the court, I don't take publicity in any consideration because I'm supposed to be objective. I'm supposed to be fair. I'm supposed to listen to both sides and make a decision on whether or not someone should be revoked or not revoked. So I want both parties to know that I don't consider whether a case is publicized or not. I just listen to whatever is presented to me and I make a decision based upon evidence that's presented to me. And with regards to motions to revoke, whether or not I revoke someone after a finding of true, that's really within the court's discretion. And State, my understanding, you wanted to respond?
I just wanted to say a few things in response to
Sure.
what Mr. Bunk said. Mr. Bunk said that probation is basically describing his client as a model probationer, and I don't disagree that they are saying he's been doing well since his first MTR.
Yes.
But they don't the extent of what he did to her, except for her and the prosecutors that have been working on it now. And she deserves her justice as well. And so that is, while it is true that he has been doing better, I'm not saying that he hasn't. That doesn't negate what he did. And for Mr. Bunk to say that we wouldn't be here if they didn't put a GPS removal in front of me, we maybe wouldn't have gotten here as fast. But when the misdemeanor case got filed, that generally triggers a motion to revoke. So I think that it's very likely we would have gotten here maybe a little later because Ms. Lopez is cooperative and does want him held accountable for what he did to her.
And let me ask you this. When is the first time that the district attorney's office reached out to the complainant in that case?
The first time I saw a note about it was August of 2024.
All right, August 2024.
Yes, ma'am.
And I'm assuming that when the case came to the state, it would have had the complainant's name and the accused name. And nobody did anything. Everybody just let it stay there. And I understand that it's not you. And I want the record to be clear. I understand that prosecutors who are in court, normally they're not indicting the case. They just end up with the case that's been indicted. I know that's why sometimes there's certain discovery that maybe you would want to be in the file is not in the file because you didn't indict it. And I know that you are not the prosecutor who looked into the case from 2024 with this complainant. I know none of the prosecutors in this court looked into this case with the complainant from 2024. So I understand, and the court is not blaming you for any of that.
I understand, Your Honor.
Okay. So to the complainant, I understand that and I have to be careful what I say because of the legal rules, right?
Sure. And I'm sorry to interrupt, Your Honor. I believe that our victim, Ms. Lopez, has actually stepped outside.
Okay.
Just so you know.
So I understand with regards to the complainant that it would have been great for them and better for them if this case would have been addressed when it happened, anytime in the year of 2024. But that hasn't happened. And I have to look at cases objectively. And objectively, should he receive some sort of punishment in this case for that? Yes. But should it be a revocation? I don't think so. So, Mr. Cantu, sometimes I can give people choices. Sometimes I cannot give them choices. Here are your choices, and you only have two. Don't ask me for a third. Number one, you will be found guilty on these cases because whether or not the state waited so late to file this or not, it should have been filed. You know that. I think your attorneys know that, and the state knows that. So I will find you guilty. I will continue you You'll continue on your GPS. Do not ask me to remove that GPS. And I will sentence you with an underline of 10 years and place you on probation for 8. Or I will revoke you on both of these cases, run them concurrent, because legally I must run them concurrent, and I will sentence you to 4 years in the prison. Do you want to talk to that with your attorneys? Counsel, you want to speak to him about that?
Yes.
Yes,
We're prepared to take the, what you said, 10/8, I think that's what you said.
yes.
That's fine.
All right. And each cause number, this is what the court will do. And Mr. Cantu, I want to let you know you're being found guilty because you should receive some form of punishment for that violation. And one of the only reasons why you're not in prison with regards waited a whole year to file it. You understand? It's because of that and because of the probation's report that you've been doing well. All right. So in each cause number, the court is going to find you guilty. The court will sentence you to 10 years in the prison, suspended and probated for 8 years. So what that means with that 10-year sentence is that if there are violations on this motion to revoke, you're looking at potentially 10 years in the prison. Do you understand?
Yeah.
And has the probation, has the restitution been paid or no? And has the, also has the fine been paid?
But I don't have a restitution amount listed.
All right, we'll need to set this for a hearing then to make sure if there's any restitution that is paid. Ms. Ferguson, I need a date in the last week we're here in December for a restitution hearing, and that's in regards to Tiffany Johnson and Walmart.
Your Honor,
Yes.
may I make a request?
Yes.
Obviously at your discretion, since he has pled true and you found it true, could we order restitution and some conditions relevant to the assault allegation?
Yes, if you all will, what we'll have to do is we'll have to have a hearing on that. So, Ms. Ferguson, a restitution hearing, please. All right, so we're gonna do that on December 15th and state, on that date, whatever conditions you believe would be appropriate, I'll have you all confer, and there may be additional conditions for your client.
Okay. Judge, and to be clear, that restitution hearing is under the clause number 1238, ending in 1238.
Yes.
Thank you.
All right. And then probation, it'll be all previous conditions. Do you need me to recite those again?
No, Judge, I do need clarification on one condition. He was placed into the ISP program, which is our intensive supervision program, on 5/13/25 upon completion of the local ISF. And he was due to discharge on that program on September the 9th. Do you still want him to remain in the program?
Yes.
Thank you, Judge.
And state, what is the cause number for the misdemeanor?
Give me 1 second, Your Honor, I have the file right here.
And there's to be no contact with the complainant in that cause number. And the no driving still stands. Oh, and I just need the cause number.
Oh, yes, it is. Okay. 2025.
Mhm.
CC 013069.
All right, and there's to be no contact with the complainant in that cause number 2025 CC 013069. All previous conditions are to remain in effect.
Just so that I'm fully aware, the GPS, I believe it's partial
For employment,
for employment only.
yes,
And his
Medical.
medical funds.
yes. All right. And then in cause number 2024 CR 1237. The court is going to find you guilty. And in that cause number, the court will sentence you to 10 years in the prison, suspended and probated for 8 years. And all previous conditions are to remain in effect. And there's to be no contact with the complainant in 2025 CC 013069. So that both parties are clear, we're going to come back on December 15th. At that time, state if you will have the documentation on any amount of restitution due to the complainant in 2025 CC 013069. And Mr. Cantu. Defense, I think.
I just did one, Judge. You probably need a second.
Yes.
Yeah, as you were saying that, I realized I didn't.
And that's the 37 number.
Yes.
In each of these cause numbers, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it? All right.
Yes.
In each of the cause number, you do have a limited right to appeal, and that right to appeal is as it relates to the allegation in the motion, not the fact that you are on deferred adjudication. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to your attorney. Do you understand?
Yes.
Ms. Scott? There you are. Thank you. Is there anything else before we go off the record?
Not from the state, Your Honor.
Not from the defense.
All right, thank you. We're going to be in recess.
What time should we be back?
proof of employment, and as both parties know, name and suspended and probated for 806. I need to set this for, and I may
Importantly,
The prosecutor.
the
Respect.
in cause number 2024 CR 1238 for the offense of evading
We barely made the airport for the last plane out. As we taxi down the runway, I could hear the people shout, and all she wants to do is.
We know the daily grind can be tough. Scooters Coffee, we believe it's the little wins that deserve some big moments of joy. Scooters Coffee, you earned it.
In the heat of the moment, we deliver cool results with ingenuity and integrity. Cool stuff.